Hi friends, this is Krish, the Urban Naxal, and today we will talk some more about how that order that RERA has passed on 6 June 2022, few days ago, is of great help not only to people who will buy flats in future, but also very good news for people who have already lost money to builders, whose money has been forfeited or confiscated by builders, and the excuse that the builders gave was this is booking amount and your booking amount is going to be forfeited as per the terms and conditions of our application form and allotment letter. This is how they put it, and people are helpless. They argue, they try to say please give me back my money. Then people will say things like my mother is in hospital, my father needs a bypass, and so on and so forth. They go into begging for their own money. Now, the thing that I have been stressing for a really long time is it is your money by law. If you have not entered into an agreement with the builder, if it is not a registered agreement, then that money which you have given to the builder, whether it is 5-10% of the consideration value of the flat or plot or bungalow or whatever, the 5-10% of the real estate, or whether it is a very large proportion like 70-80% which you have given but you have not entered into registered agreement. This happens to people sometimes. They end up giving huge amounts of money, 30, 40, 50, 80% of the money, sometimes 95% of the money, and yet they have not entered into a registered agreement with the builder. That money is intrinsically theirs because that money is in the nature of a deposit with the builder. A deposit with the builder means it belongs to you, does not belong to the builder, has not become the builder's, has not gone into the project, has been lying with the builder, cannot be invested in the project. It can be used for the project as funding for the project only if he enters into an agreement with you and you write, a certain unit is written down in their agreement. Let us call it D607. So D607 flat number in say a building called Lotus. Only then can the builder use the money for Lotus. Otherwise, the money is lying with him. It's a deposit. It is not his money. It has never been his money. Now, a lot of people are going to ask me, Krish, they are already beginning to ask me, Krish, I have paid money earlier. This order which you are saying has come now, few days ago. Is this order applicable to me? How is this order useful to me? This is one question. There is another question. The second question is, people call me from Karnataka or Delhi and they say, listen, this is an order passed by MahaRERA, Maharashtra RERA. So the competent authority whose jurisdiction is only Maharashtra. And of course Goa, Daman, Diu, because they have been given jurisdiction over these union territories. How are you able to say that the amount should be refunded if I am in Karnataka, if I am in Delhi? How are you able to say that I can use this order? Okay. So here's my answer to both those questions. Number one, you have paid money before. And number two, you are living in some place outside Maharashtra. Both these things, let me answer you. Why this is useful? Now, it is of course most useful to people whose order, who are now in the time period, who will now in future be booking flats. Of course, 100% true, it is most useful to them. It is also most useful to people who are living in Maharashtra because it will fall squarely within the jurisdiction of MahaRERA. Both these things are true, but it is also useful to people living in the rest of the country and also useful for older cases. And here's my explanation why it is useful. The explanation is like this. Friends, what MahaRERA has passed is an order. You need to understand what is an order. An order is an interpretation of the laws as they exist. MahaRERA has not passed a new law. There is no new law. RERA is the new law. The new law was interpreted, and not just the law, but existing laws. So not just RERA Act, not just Real Estate RERA Regulatory Act, but existing laws such as Indian Contract Act. They existed. They govern your transaction with the builder at all times, even before RERA. There is also an act called MOFA, Maharashtra Ownership Flats Act. There are various other acts. Okay. So the various other acts and laws of the land that exist have been interpreted through this order, and a certain balance has been struck between the interest of the builder and the interest of the buyer. Any grey area has been taken towards black and white, so they have sort of divided it up. And then they have passed an order which is an interpretation of the law. Now, what does this mean? The law already existed. So for those of you whose money was taken away by the builder in the year 2022 but before June, or in the year 2021, or in the year 2020, you guys can still argue the matter in court. You can go to RERA and you can cite the same order, and what you need to say, what you need to explain to the judges, of course, the builders will try to give the opposite argument. The builders will always, builder side lawyers will say, sir, this cannot be made retrospectively applicable and so on. Correct. Nobody is talking about making that rule, that is the order number 30 of 6 June 2022. Nobody is talking about making it retrospectively applicable. We are not talking about that. What we are talking about is this. You have passed an order. The order has been passed in the light of so many laws which are made in the parliament, passed by parliament, old laws, existing laws. Not just limited to RERA. There is RERA, there is MOFA, there is Contract Act, and then there are so many what we call judge-made laws. Laws made by judges. What is a judge-made law? When Supreme Court passes a judgment, that judgment becomes applicable. You can cite it, you can quote it anywhere in India. In fact, even where High Court, any High Court, passes a judgment, yes, to some extent its judgment and the scope of its judgment is limited to the jurisdiction. Like Bombay High Court has passed a judgment, so its limitation area is Maharashtra. But suppose Madras High Court has passed an order, and that order was passed in, let us say, the year 2000. That order still has some indicative value. It has some value, suggestive value. You can use it as an indication of what the law says. You can quote from it. It has a certain amount of weightage which you can use in your arguments. Now you are going to say, Krish, we are not going to RERA. My money was lost in 2019. I don't want to go to RERA. Fair enough. You don't need to go to RERA. If you carry out a correspondence with the builder citing this order, okay, you may not have carried out the correspondence till date, but you now start. Now you start citing this order. Quote this order and say, boss, you have to refund my amount. Let them reply to you. They will not reply. They will try to avoid. Address your correspondence to the company secretary of this of this builder company, or address it to the company secretary, address it to various the directors and executive directors and all these people and higher ups within the management, address it to them. Make them answerable. Address the thing with proper legal arguments. They will try to avoid reply. They will not reply. Within a week, send them a reminder number 1. Within another 1 week, send them reminder number 2. Within 2 or 3 weeks, send them 1, 2, 3, 4 reminders. Now what you are doing is, when you are sending these many reminders, you are making them answerable if you should go to court. So then if you happen to go to court, if you choose to go to court, you will have an extremely strong case. They will have to answer why they did not reply to so many reminders. Why they did not reply to your correspondence. They have a duty to reply to your correspondence. Make your correspondence about the law. Make it an argument or a discussion about law, the legal position. Tell them to escalate it to their legal team. Why are they not replying? They are supposed to reply. So what happens is, you are kind of boxing them in, you are closing them into a box. Then you can start copying to police commissioner, start copying to chief minister and other basically authority figures, urban development department. Now what does this do? Now we are exerting social pressure on the builder. We are telling them, listen, this builder is a crook. This builder is a cheat. He has taken away 10 lakh rupees belonging to me. And he doesn't want to answer for it. And now, so I am raising my voice. I want you guys to know it. I want all the competent authorities to know it, whether you take action or not. I want the police to know it, whether you are actually going to do something or not. Now it becomes very difficult for them to keep your 10 lakh rupees, not reply to you, not reply to all these people, because some of these people might start asking questions. They'll say, boss, what's going on? We are getting a lot of emails nowadays. A lot of people are writing to us, and of course we are in CC, you are the main people, but they are saying, give us our money back, give us our money back. Is your business going okay, or are you doing something wrong? They'll start asking on an informal basis. That makes a difference. That has an impact. Do this. You can do this. Now, this was my advice to people in Maharashtra whose token was forfeited a year, 2 years, 3 years, 4 years earlier. They have to reply to you. Okay. You can also take up one other strategy. They have taken your money. They have not given you an allotment letter. Start asking them for an allotment letter. What this order says is, within 15 days of the allotment letter, you can cancel. You can say, sorry, I don't want it, and they have to give you the entire refund back. Now suppose you already said, I want to cancel. Suppose you have said it in writing. Suppose you have sent an email. Suppose they have sent you a reply saying, we have forfeited your amount. Even then, you used to say, alright, but I have the right for an allotment letter or not? You have taken my money. You have taken this much money of mine. Give me an allotment letter. You can go after them. You can try to, okay, so now this is, as I say, ye shaitani dimag chal raha hai. Here I am using my devilish brain. Okay. What you are going to do is, you are going to create a situation for them where they are arguing. They are trying to fend you off. Earlier, when you had given them your money, whether it's 1 lakh, 3 lakhs, 10 lakhs, 20 lakhs, whatever, you had given up. You had forgotten about it. You had stopped talking about it. Now you start talking about it again. Now you start giving them hell. Now you start using that as ammunition. You weaponize it. Send it to them again and again. At some point you can make a video with me about this. Let me give you an example. Suppose there's a guy who lost a lot of money to Runwal 5 years ago. 5 years ago or 7 years ago, in 2015, let me say that Runwal or Lodha or Godrej took away this person's money. Let us say the amount is 5 lakh rupees or 10 lakh rupees. Now this man has left it He has sort of given up on it, but it is still hurting him. Daily he wakes up in the morning and he says, if only I had those 10 lakhs, I could have taken my family for a vacation. So that regret is still there. Now the law says that after the limitations period is over, you cannot try it for debt recovery before any judicial forum. Fair enough. Fair enough. Agreed. You don't break the law. There is no law that says that Runwal or Godrej or Ronak or any builder who has taken away your money is entitled to your silence, is entitled to you keeping shut, not talking about it in social media. There's no such law. So you can't go to court. All right, not a problem. But the fact is, you can still tell the public, listen, this guy took away my money. He's done this kind of unfair dealing with me. And on what basis will you call it unfair? You will call it unfair on the basis of this order passed on 6th June. Why? Because this order passed on 6th June has drawn the lines. What is fair and what is unfair? When it is fair for the builder to take your money. So what are the lines? The line is very clear. Allotment letter pro forma has to be uploaded on RERA at the time when they get their registration. They can't say no, we will do it later. Point number 1. Allotment letter pro forma has to be uploaded on RERA. Number 2. Allotment letter pro forma has to be as per RERA. As per the RERA model allotment letter, which is there as part of the order, as the annexure. So that is your point number. That's the where they drew the line. It has to be as per that. Now in that, agreement pro forma has to be again uploaded on RERA and given to you immediately along with allotment letter. When they issue the allotment letter to you, they have to give you the agreement. If you have swiped a token, they have not sent you the allotment letter, it means you are free to withdraw. After they give you the allotment letter, let us say you swipe a token today, let us say 7 days later they give you the allotment letter, they issue an allotment letter. It has to be exactly that what RERA is telling you, exactly that same pro forma, no difference. Okay, it has to clearly say we are allotting the flat to you. They can't do all this hanky panky of we are considering allotting the flat provided you meet so and so conditions. No bullshit. All the bullshit has been cut out. All the wiggle room is out. The builder can't wiggle around. Okay. So it has to be exactly as per that. And what do they say in that? They say when you can cancel your booking. Within 15 days of getting this allotment letter, you can cancel and they will have to give you money back 100%. Okay. So from the time you swiped your token till the time of allotment letter, of course you can cancel. After you get your allotment letter, another 15 days also you can cancel. Now what is cancel? Cancel means write a letter, write an email saying please cancel my booking, or rather please cancel my application for booking, because the booking has not been given to you at this point. Booking is given to you vide the allotment letter. So you may say please cancel the allotment letter. Give me back my money. Refund it as per the terms and conditions of order number 30. Refund the money to me. Okay. 15 days. After 15 days have passed of allotment letter, you are entitled to, they are entitled, the builder is entitled to forfeit your 1% of consideration value. Now remember the difference between what used to happen earlier and what happens now. Earlier they used to take 4-5% immediately, maybe 10%, and then they used to say we are forfeiting this entire amount, this whole thing is the booking amount and token. Now after 15 days, on the 16th day onwards till 30th day, 1.5%. I am so sorry. 1% is what they will forfeit after 15 days. Okay. Then 15 days to 30 days or 31 days, I think. Check it out. There will be this period of 1%, and after that it is 1.5%. So 1.5% if you say after 1 month. And then after 2 months have passed, if you say, sorry, I want to cancel, I don't want to go forward with the deal, then they are allowed to forfeit 2% of consideration value. What is consideration value? Not GST, not everything else. Consideration value. Of that, 2% means if your flat is costing 1 crore, then they can take away 2 lakh rupees and say this is our forfeited amount as per RERA. Okay, this is the law. Or rather, this is the way the law has been interpreted. You don't need to give a reason for cancellation within 15 days. Actually, you don't need to give a reason for cancellation at any point of time. But remember one thing, if they have deceived you, if they have misinformed you, if you can prove that they have misinformed you, then you can argue for even getting entire amount back. Entire amount. Because if they have deceived you, if they have not properly informed you, if they have kept you in the dark, if they told you a wrong date and all, they are supposed to write the date, the progress, everything in the allotment letter. Please read the allotment letter carefully. It is not very difficult to read the allotment letter. It is not a large allotment letter. Read it. Okay, now I am talking about people outside Maharashtra. Say West Bengal, say Delhi, Haryana, Gurgaon, say Karnataka. You can use this as a model before your RERA. When you argue before your real estate regulatory authority, you can say, sir, after all due consideration of the existing laws, Maharashtra RERA has come up with this order. This order defines the lawful position, arguably. And if you pass an order which is beyond this, I will go to court. So if you say, for example, if your Karnataka RERA passes an order saying, oh, the builder can forfeit whatever he wants, or he can forfeit 10%, then you are enabled to go to court. You can take it to High Court, and you can, in High Court, you can argue using this Maharashtra RERA order. So in this way, the Maharashtra RERA order strengthens the hands of all the people arguing for their refund of token in any state of India. I hope this was clear. I'll try to make it even more clear. I am your friend, Krish the Urban Naxal. Jai Hind, Jai Maharashtra, Jai Jawan, Jai Kisan.